6:43 p.m. Thank you. Do we have anyone signed up for public comment?
No, Chair, we do not.
Okay. The first item we'll get to are the minutes, consideration of an action on the minutes of January 30th, 2025. Does anyone have any changes, additions, corrections for the minutes?
Make a motion to accept the minutes.
Okay,
I'll second.
second. All in favor?
Aye. Turn your mics on.
Yeah.
Minutes approved.
Good.
Okay, our next item on the agenda is to review the recent articles of interest. I think it's very timely and interesting. It's, relating to campaign environment, elections are coming up. So I think Meredith found a great article for us to review. How we do this, we have a lot of new faces for this kind of a discussion. It's a little bit old hat for some of us, but what we'll do is we'll review the actual contents of the article. It's amazing. We have the actual complaint itself and the different allegations. And what we can do is walk through those and apply them to our code that we have today, including the red line changes, so that we can see how those would apply in this situation. And then we kind of debate and just see where we all stand and what we would feel or assert based on the code itself. So with that, there were many allegations. But
Yes, there were.
normally it's like the allegation is or are, but there are quite a few, and we'll walk through them, but it's relating to, anybody want to help me with the name?
Car. There, I know one person is Kaur, Car, and then the other was it was a hyphenated name, like.
Julissa Madrano Guerrera.
Yeah, Guerrera.
Yes. So the first complaint, if we want to turn to, and in the packet, it's on page 23 of 26. And does anybody have any general observations first before we go through complaint by complaint? It's basically the overarching assertion is that she, in my words, utilizing her office in a way that is against their code of ethics, but with the specifics outlined subsequently. Did anybody have any general observations before we dive into the itemized complaints? Okay, great. First complaint was use of city resources for campaign purposes. The complainant alleges that the councilwoman Carr, chief of staff, Ryan Saltz, attended a neighborhood association meeting in an official capacity. Introduced himself by title, presented information, and then at the end, upon conclusion of the event or meeting, he began to distribute campaign signs, was taking campaign photos, and discussing prospective re-election for Carr. So I'm going to open it up for discussion. Do we think this would be a prospective violation of our code as it is written? And if so, what section? How would you interpret this?
My question was this part of the official meeting, or had the meeting been completed and then her activity was post-meeting? And does that make a difference?
It said it was post-meeting. It says immediately after, based on what's written. However, immediately after the official portion of the meeting, Saltz began distributing campaign signs, taking campaign photos, and discussing Carr's re-election campaign. I mean, right after the meeting. To me, that's connected. It's a little too close.
That's why I had a question.
And I believe we've been told several times, you have to know which hat you are wearing, and that certain people can never take that hat off, no matter where they are.
So I found it interesting, and I have to refer back, but it was an employee. right? So I mean, it's,
Hmm.
I believe employees are subject to a different policy and procedure. So that would be my first question is the person that took the action, are they governed by the code? So my interpretation would be that Salts is not necessarily subject to the code. Now, if the allegation said something more specific that Carr directed him to do this, I don't know if that could then go back onto Carr as far as like, initiating the action. But I believe that Salts would not be subject as an employee to our code, the way our code is written and who it governs.
Is his position an appointed position or an elected position?
Chief of staff
Chief of
usually
staff, mhm.
appointed.
It says functioning in his role as a city employee. So I would assume.
And it's,
employment
he's,
arrangements.
yeah, and he's chief of staff.
Mhm.
We don't elect the chief of staff.
I agree with Andrew with the different hats, but why wouldn't 2-82 appearances apply in this situation?
So it's interesting, you went to appearances and I went to representation, so that those kind of two sections go hand in hand. What part of appearances, right?
They're required to disclose to be in speech or writing. I mean, it doesn't clearly state whether he changes hats. When he goes in there, so I mean, the whole paragraph really applies to this situation.
He's just not defined as an official.
Yeah, he's not an official, he's not considered an official.
Chief of staff's pretty official today. I mean, it's,
So I think that's where we would go back to. Let's see, our definitions
Well, it does say he went
on her behalf.
in his official capacity as city manager. So he was acting as an official.
Yeah, city representative.
He wouldn't have been there if he wasn't for that activity.
So in our code, we define official as, oh, and I don't have the red line, because did we modify this particular part?
Yes.
So look at 284,
That's what I was.
Mhm.
yeah.
where it says they're not allowed to request that any city employee participate.
Oh, that's,
In any political, yeah.
Yeah, an official or candidate must not knowingly request or authorize anyone else to request that any city employee participate or not participate in any political activity, including the making of campaign contributions.
so then there's two phases of this when we discuss it too, right? Is there additional information that we would need and that we'd want to request? And for our procedures, if we were to receive this complaint and it has gone through Meredith's office and she said that, they're subject to the code and it meets all the criteria, we would first look at it and say, does this warrant an investigation?
Mhm.
And so based on some of the discussion under 2-84, my question would be like, did you have direct request to do this? Right, like what was, even if it wasn't in writing, you could verbally instruct him to do that. And it would be at her direction.
Well, and the last sentence says, the circumstances strongly suggest. That doesn't mean it's for sure, but strongly suggest that he may have been directed and pressured to do so by the council.
So in part of the hearing, if we were to vote to hear it, you would then question Salts and say,
Correct.
were you directed to do this? So, but as a whole, it looks like it would be something that warranted further investigation and not dismissed as
absolutely.
frivolous.
Yeah. Agreed. Well, you could even look a little bit at 286, even though it says misuse of city property, it does include the term personnel in there.
Mm.
For profit or personal convenience or benefit, except when generally available to the public. And in that case, the use of that staff member to any other person running for office, they would have not had that availability.
Oh, that's a great point. Any other comments around item 1? So item 1, it looks like we would investigate, we'd want to speak with Salts and understand if it was at her direction. Salts would not be subject to the code, but Carr absolutely is. Okay, Any other?
would we want anything, I mean, it would be an investigation, so we've got the changes, and I realized my first one of the red line. Is there anything that we would want to modify or say in our code if we wanted something more specific for a person like that, or could we?
For the role, you're saying itself, so like a I'm gonna let Meredith take that one, because I believe that she can speak to the requirements for city employees.
Okay, so this one would actually be a penal code violation and an election code violation. So you cannot use city resources for campaign purpose. I see Linda over there because this is her jam. But from the employee handbook, yes, this would be a violation for that employee. As you're going through these, everything is bifurcated. So you're gonna have your first go or no go hearing where you get the complaint and you
Right.
say, yes, I want to move forward with this. And then you say, this is the additional evidence I need. Once we give you that additional evidence, you have your second hearing and you go through all that. Once you're done with it, all of it's done, completed, you've issued your opinion, I come back for your next meeting and you say, these are some items we would like to put to amendments. So the amendments would be separate from the hearing
Mhm.
because the hearing is exactly what you have in front of you.
Yeah,
Whether it be as the complaint and the statute as is the code. And then after it's all sealed and done, you've passed your verdict, then we can talk about any amendments you would like to have made.
that's perfect. Thank you.
Krista, you mentioned that we would probably do an investigation of just SALT, or would of the city official, the elected official as well, as part of that investigation?
I would say that it's an investigation of the complaint. And so the investigation could be testimony from SALT, testimony from CAR, other people that may be a party to it, documents that may be relevant. Say there was an email with a formal request, can we see that email? So I would, in my term, and Meredith can speak to it more eloquently from a legalese standpoint, but we investigate the complaint versus an individual. Getting a no. Anything else on the first allegation or complaint? Okay, the second one is involving coercion or alleged coercion or improper direction of city employees. So the events at the Lavaca meeting opened up more formal or serious concerns that city employees may be implicitly or explicitly expected to perform political work. And this, in my mind, also points back to what Meredith indicated about penal code and infractions in that regard. But to what Chris indicated earlier, I do think there would also be possibility here under, was it 2-86, when it was like direction of use of
Improper use of city property.
city property or personnel, yeah. Thoughts?
Read of that. We would definitely look into that. And it probably should not have been done.
So
That person salts, they don't live in that HOA, is only at that meeting. Or to gain information about that or the boss, and is there for political purposes.
When you're triaging, and I don't like the word triage because that assumes, certain level, but when you're reviewing the complaints initially for those criteria, if it is in direct violation to like a penal code or employer, policy and procedure or something to that effect, how does that work if it is also governed possibly by the code of ethics?
So it would actually be a two-step process. So I would write my opinion to. Yours. Sorry, getting feedback. I'll turn mine off in a minute. So it'd be, I send you your letter, I say, yes, this council member is subject to the code. Yes, this behavior happened within the 1 year required of the code. Yes, they have cited 284 or 286 of our code. If this is true, it might possibly be a violation please investigate. At the very conclusion, I will say a number of items may also be a violation of the election code or the penal code. And then I would take that over to the police department and let them look at it. That would not be for y'all to decide. As far as being a violation of an employee, if that comes up in your discussion, our outside attorney would tell you that the attorney is not, or the employee is not subject to this code. Please focus on the elected official.
So we would still, it would still move through our process. It just would only be whatever was subject to the code itself. And the
It-
other is just extraneous.
It'd be limited to your jurisdiction, yes, ma'am.
So if the employee were being investigated by the city and we wanted to have them as a witness, would it most likely be the situation where we would have to hold off on our investigation because they
No,
might
you
incriminate
have a
themselves?
You have a time requirement in the code, so yours would go first, we would do ours on the side. And it would be basically whether or not we have an agreement with them that they can't incriminate themselves. But it wouldn't be if it's a criminal charge, we do a Garrity warning. If it's just an employee handbook violation, we'll probably just say it is what it is, here's your written reprimand. But they would still be compelled to cooperate if you guys list them as a witness.
You know, just like on the first one, as well as the second one, obviously, we should investigate, but we need hard evidence, right? To proceed. I mean, words like strongly suggest,
Maybe.
and, you know, that raises a red flag for me. And how do you investigate something like that? I mean, you have to take the whole entire board of the, what is it, the Lavaca Neighborhood Association, into interviews. And, you know, what would happen here? Because it does violate a number of our ethic codes, but
Well, and I think it's interesting, and I keyed in on at the end, where some staffers may have been coerced or terminated.
Yep.
So that to me is like some sort of an implication that somebody is no longer with the city in direct relation to that. And if that is the case or the assertion, why would you not?
investigate.
Well, but why also, and it's not for us to decide, right? The complaints come as they come, but I feel like that is more egregious and definitive sounding than some of the things earlier on in the complaint.
But there you have, again, may have been, I mean, once it comes to a point where we need to go forward, I mean, we're wasting a lot of our time if we don't see hard evidence prior to. I mean, this is all speculative to this point, which is our job. I get it, but
I think too, and I think that's part of the discussion too, when they come in and we have that decision-making process is to decide whether or not we move forward with the investigation or not. So I think opinions like yours would be heard at that time and we would all, you know, vote to determine what the next steps are. Do we feel like they provided enough substantial information
hard evidence, yeah.
that this, you know, these are the complaints. We do ask in our complaint process to provide evidence or evidentiary support for those complaints. And as these were submitted, no evidence in my mind, like formal, like here's an email, here's, you know, a screenshot or here, whatever it is, have been provided. So that would be a discussion, I would think, as to whether or not there's enough here.
Yeah, I mean, I was telling Meredith, I had sat on the state judge judicial conduct, and this is very similar to cases that would come there. And so we would look at it and the department there would first decide if there was enough if there was enough there to even bring it to our commission. And then there were times even in our commission, we'd still dismiss it even though they thought there might have been evidence. So I would say the same kind of thing would occur. We either decide to say yes, go through an investigation or not.
And I think sliding scale is not the right term, but it also depends on what the allegation is too, and like how egregious it might be, and you know, what the implications are if this did occur. You know, if somebody lost their job because of, you know, not wanting to
Yes.
engage in behavior that's contrary to the code, that's pretty serious allegation. Any other comments or observations on complaint number 2? I think Meredith too, procedurally. I mean, I could see a scenario, and not with this specifically, where we're like, okay, dismiss 3 and 4, we want to look at 1 and 2. Would we procedurally look at 1 and 2 separately? If they were, 1 and 2 right now relate to each other, but hypothetically, if 1 and 2 were complaints against the same person, but like 1 is a conflict of interest complaint and another is a representation or appearances complaint. Is that a decision that we have the ability to make, or is it all done in a cohesive?
It's gonna be case by case. So you may say, looking at the facts, you may say, okay, they have alleged 4 violations of this section. And you may lump it together by the section, say, okay, 1, 2, 5, and 6 all relate to 2-84. Let's do 2-84. We're gonna move forward, focus on this allegation. Or you may look at it and go, oh, well, it's actually a violation of this. They named the wrong one. But as you go through, it's organic. So you will decide which ones you like, which ones you don't think meet the standard. And then you'll tell your outside counsel who's sitting there and say, okay, these are the ones we would like to investigate. This is the evidence we need. These we're gonna dismiss as frivolous or unsubstantiated or not enough information.
Because I could see scenarios where it's all under one, one submission to you, but it could almost be like 2 separate public hearings because there's so much, the information needed, the people needed, and that kind of thing could be
You're always gonna have 2 because you're gonna have the
the
first
first and
one.
then.
And then you tell us what you need us to bring forward. Staff will then gather the documents and the people and have them show up. Your second one may take several meetings depending on how
Yes.
complex it is, but that's the one where you're interviewing people, they're giving testimony, you're looking at the documents. But it's gonna be organic, so whether you do it by section or by scenario, it's gonna be what works for that set of facts.
That makes sense. All right, are we ready to move to the third? Complaint, failure to disclose financial interest. So, the allegation is that there are a number of different interests that, have not been disclosed. That they are omissions, and these omissions obstruct the public's ability to evaluate their financial interests and potential conflicts of interest. Initial thoughts. I mean, there's a role as president of the foundation, financial interests, business interests. What are your thoughts?
Doesn't pass the smell test.
What part of our code would speak to disclosures?
Let's see, 770. The 2.77 talks a lot about the conflicts of financial interest.
And 272, right, that part B about, they must not have any financial interest or engage in any business transaction.
It's a state law that they have to file the personal.
Mm-hmm.
Conflict of interest.
So that would go to election.
It's the local government code. We just got our annual reminder that we have to file that by the end of April. So we have to do, we mean the elected, the council members, the city manager and myself have to fill out a form that talks about how much our house is worth, who we owe money to. It's a fun form to try to go through all your businesses. Fortunately, it happens after tax time, so you've already got the documents. But yes, that is where you disclose it. Under our code, section 277, if there's an item on the agenda, then they would have to do an additional disclosure with conflicts of interest.
So then based on that information, is this particular complaint subject to the code?
I believe so, yes, because if you look at, going back to 272C, officials have the responsibility to conduct themselves in a ethical, embrace honesty, accountability, respect, and trust. And she serves as the president of a foundation, and she's not being upfront about that. That certainly warrants looking into that further. Why did you choose to omit that information?
Any other thoughts?
Yeah, so, if she owns a bar, the city licenses and permits that bar. I would imagine. So she can easily have influence over.
So this particular complaint is to my, like, based on my inference, it is strictly about disclosure
Mhm.
and disclosing of financial interest.
Right, because I think that's later where there's more about the
Conflict,
conflict.
yes.
And it's not false information, it's just failure to disclose it.
Mhm.
Meredith, this came across your desk and you were triaging it.
I would not send this section to you. I would say this is covered by state law. Now, San Antonio may have a provision in their code that addresses this. You do not.
Now, we'll see how that evolves as we get to the subsequent ones. So this one wouldn't come across our desk. So number 4, failure to reveal a court judgment and lien.
It sounds like it goes back to where the third one goes, of you violated state law, not our policy.
Mhm.
Anyone disagree? Right. Number 5, conflicts of interest and pay to play concerns. The complaint alleges that Councilwoman Carr received at least $34,000+ in contributions from a variety of 22 individuals and business entities with ongoing or pending matters before city council. And that she has previously voted 13 times relating back to these contributions.
No, I mean, all of this sounds a lot like 2/7. I mean, it's all conflicts of interest. Jeez.
At 279, if the city owns the airport, she shouldn't be participating in any conversations or votes.
Well, and what is it in 277B maybe? They're also supposed to file a conflict disclosure agreement and none of that's being done. Clearly, she doesn't see that there's a conflict.
Well, and also we're looking at, I don't know what their code says. I would assume it had some sort of provision for filing conflicts of interest. But here, our code states that you must
Mm-hmm.
file without knowing their code.
I would like to point out at the last revision, first reading, you guys did adopt a provision that requires them, anytime they get a campaign contribution from somebody exceeding 2,500, they must file and abstain. So that won't be on the online version, but that is something that will be passed next week.
Right, and according to this, this was 3,000, so it would hit that limit.
Yeah.
So it sounds like we would want to investigate. What types of information would you want to see?
I would want to see what she voted on, motion and what she voted on.
I would also like to understand, and this is more conversational, but speaking to other parties on council, about types of conversations prior to the, using your.
Influence. Mhm.
But also, to your point, if you file the conflict in it and it's, meets the criteria, abstention is the next.
Yes.
Mhm.
So those two go very hand in hand. I definitely think that would be something that we would want
To investigate.
to discuss. Well, anything else anyone you would want to interview or documents you would want to see?
Want to see all of her campaign contributions at that point.
Yeah, it says that Johnny Hernandez, who along with his family had donated over $3,000 to her campaign. What does that mean, along with his family? Did everybody contribute to the max? I mean, that might not be troublesome of itself, but that would be interesting still to note.
One, especially as you're looking at the dollar amount, not super familiar with contributions and how they're lumped together, but is your thought that if, it may not meet a certain threshold if it's divided up between different parties?
Yeah, or, what does that mean along with his family? Like, did 20 of his family members all contribute the max, or what does that look like?
Any other thoughts on complaint number 5, conflicts of interest? Okay. Item 6, undisclosed or misleading professional history. And this has some allegations that she has misrepresented her employment history, her LinkedIn profile, her duration at the San Antonio Area Foundation. Thoughts on this?
Seems pretty basic. I mean, it applies to the section 2-72. And then like I said, section D, I mean, truthfulness of her personal conduct and ethical behavior.
However, you can write whatever you want on LinkedIn.
Pretty
And
sure it's not an official document.
exactly, so,
Yeah.
so there's that side of it. I mean, yes, if I was elected, I'd want them to be honest.
Mhm.
However, I do know, especially in work I'm doing, what people can and do say on LinkedIn.
I can
Is it
be
truthfulness?
convinced otherwise, but I'm not certain this is subject to our code.
Mhm. I mean, that's what we're going through all, I mean, like, that's a stretch, is that one, and that's about the strongest one we
And
have.
so that's an interesting, when you brought up the ethical values section. I think that's interesting, and it's directional, like how we expect you to conduct yourselves. I think it becomes very, very gray as far as
Mhm.
enforcement of such section. I think, we tend to look more towards the actual, so Division 2 is where the code, in fact, and Meredith, keep me honest, but I think, that Division 2 is the actual code itself, where it starts at 275.
If you were to look at section 2-97, it says a complaint alleging a violation of this code of ethical conduct, and you're correct, Division 2 is the code of conduct. The Division 1 is feel good language, but your jurisdiction is Division 2.
Thank you. So I think, as Meredith was saying, Division 1 is the spirit in which the code is written and drafted, and the values that we all subscribe to. But really, when you're looking at violations, you have to go a little bit further down.
She certainly didn't avoid the appearance of impropriety.
Agreed. Mov- Moving along to another conflict of interest
Mhm.
relating to a nonprofit and city funding. There's a foundation where she was formerly employed that currently provides funding initiatives managed by the Housing Trust Foundation on a board that which she now serves. And she has received political donations from several senior executives involved in the grant making. She's voted in favor of pursuing grants from the Trust Foundation projects. Assertion of overlapping relationships. What do we think?
They had 277 on that one.
Can you explain her conflict?
Well. No. You messed me up with the paragraph 3. No, go ahead, move on.
That's okay. Anyone else have any thoughts on?
277(7) maybe. Or a public-private business entity for which the official or his or her relative serves as a director, general partner, or officer. Any other policymaking position.
It's kind of like based upon what SAAF is founded on, but it could be a non-government civic group, social or charitable, so it would be C6. So right above that.
So would we investigate? I mean, it's confusing and it is overlapping. And so would we say to investigate or not?
Steve's pointing out the 277C.
Yeah.
I would lead us to, I would say yes. Look into it.
Yeah, that one seems to be the most,
Mhm.
the simplest and easiest to make that connection to is 277C.
It is a violation for an official to, within 2 years of entering city service, award a contract or participate in a matter benefiting a person or entity that is formally employed, that informally employ the official. I'll get there. So is the city in this instance or in this allegation, have they awarded contract or benefit to this foundation?
Well, she has voted in favor of pursuing grant funds for SAAF for the Housing Trust Foundation projects. So if that vote was finalized, she was part of that voting to do in favor of it. Yeah.
But it's also grant seeking. She did, she's not necessarily because she said that she's gonna want the grant, she's gonna get the grant.
Well, yeah, and I don't know if it's in the voting. Again, it's one of those, do you investigate and then ask the
It definitely
people?
doesn't have enough information
Mhm.
as it stands,
Yes,
and
yeah.
that's where I'm kind of leaning.
Yeah.
Mhm.
That it also says she has also voted in favor, as you said, as pursuing grant funds. Where I get confused is she serves on a foundation, so is she voting in her capacity as a city official, or is she
Mhm.
voting on her capacity as a board member? So that's where I'm unclear of how this is written.
Mhm.
So it is vague.
Yeah,
Very cloudy.
And I think too, having an appreciation of things that were recently on the city council agenda and understanding how these foundations interface with the city itself, I think we would have a little bit possibly more clarity as to
Mhm.
making that decision, whether to investigate or not. Steve, I just want to give you another chance.
Sorry, buddy. Yeah, the other thing I had down here was 295. And we again, look at the campaign activity. 295, paragraph 2. Now, I don't know if that would apply to this situation, because we are talking in part campaign funding as well, are we not?
Possibly, because it does, it
Kara has
has received
received
political donation.
several senior executives involved. It doesn't say, I mean, what amount of money are we talking here? I mean,
There's
it's.
a lot of
it's-
missing
it's-
information.
There's a lot of,
Mhm.
right.
And I think in our,
That's why you need to investigate, I think. It's,
Definitely.
you need more information.
I think too, and I'm not saying this is like how we would vote, but I think part of the conversation in our red lines. And I'm flying blind, so bear with me, but in our red lines, we spoke about dismiss as frivolous or dismiss as basically needing more information, that they did not provide evidence and support for whatever the allegation is or the complaint. And so I think this possibly could be a discussion where we say, okay, we're not saying that this doesn't warrant an investigation, but what we are saying is there's so many missing pieces to this puzzle that, you know, you really don't even know where to start.
They may
Yes,
need to resubmit the complaint.
correct.
Yeah, because she could have disclosed all this information. We don't know if that's been done. I mean,
Mhm.
I mean, she filed the appropriate disclosure
Mhm.
forms. This would go nowhere.
Definitely sounds like there's
That's
gray in
worth-
the disclosure.
Worth investigating, sure.
Additional ethical red flags. Accepted campaign support from a PAC. Conflicting public statements about her DWI conviction. Disclosure of said conviction. And absenteeism. Does anyone want to take a stab at any of those?
Is DWI moral turpitude? There goes that.
And that's a charter provision, so still outside your jurisdiction.
Something we discussed as a board in your defense, but yes, outside of the purview of the code. I would like to say, I don't believe absenteeism falls within the purview of our code. That's out of our,
Right, there could be some rules around the official and what their rules of engagement,
Sure.
what they're supposed to be, but it's not part
Not
of
for us.
us, correct?
correct. Anything else in section 8 or number 8? That looks,
I go back to my similar comments in section 7, on the disclosure, section 2-95. I mean, there's a bunch more information that we.
I think across the
amount of money.
board.
Mm-hmm.
I think that's like an overarching theme on all of these, in my opinion, is there's definitely some that's worth discussion and possibly might be egregious enough that we say we need to open the investigation and seek that information, but there's many of these that my opinion would be dismissed, stating there's just not enough information. And then there's some that obviously don't fall within the purview of our code. Go ahead, Andrew.
Oh,
Oh. You're gonna say something.
But during the complaint, shouldn't we require that information? Give us some hard facts of why you're submitting this information. So we're not wasting our time as a board.
Yes, so
Correction.
I believe in our red lines, we request that within the complaint that you provide support for your complaint. Now, obviously, you're not gonna have testimony and you're not gonna have, you know, the information you don't, but something to substantiate what you're alleging.
More than what you're,
Yes, sir.
and which part of our code it violates has to be
Yes,
submitted to.
yes. So when you file the complaint, you were like 2-76, you know, whatever section I just named. Here, 2-95 campaign activity. And, you know, subsection B. This happened, and here's a document that shows this is what happened. That, I mean, obviously that's best case scenario. We've seen things of all shapes and sizes so far. And, you know, that's the role of the board, is to review and discuss and to either decide to investigate or to dismiss, and either dismiss based on frivolous or whatever the rationale is.
But also to avoid hearsay and speculation.
Mhm.
I mean, come to us with hard evidence. If you don't have hard evidence, with this would even pass the smell test. Why would we pursue any of this with this type of information?
Yes. I think it is helpful to have the support, or at least enough support that shows that there's some meat to it.
If a complaint doesn't have the support that we're looking for, would it be for us to go back and ask for additional support, or would it be thrown out on a technicality?
I don't have it in front of me, but for that initial hearing, we can vote to investigate, or we can dismiss, but we can dismiss. And then there's some additive language that I don't have in front of me. That was something that we added. It is part of our proposed revisions to say, you know, we want to be able to dismiss this and say there's no support here, but we're not saying it's frivolous, meaning like there was no merit to your complaint. We're saying it's frivolous in the sense that we don't have anything here that shows we should investigate.
So we would provide the complainant with a reason for dismissing it. And that would be clear to them that if they want to go back, get more evidence and refile it, that they're not precluded from it.
Right, it's not a double jeopardy kind of thing, or, because it's not, you know, that kind of thing.
The legacy language is on that initial public hearing is we review the information after it comes through Meredith's office and she says that, you know, you should review this and it's subject to the code, etc. Dismissed as frivolous, dismissed because the subject conduct was taken under good faith reliance on formal written opinion of the city attorney, or investigated. We have since revised that and kind of left up that language a little more, because it felt so cut and dry that we didn't want to say something was frivolous, meaning it was without merit, but it was missing information.
Right. Understood.
So our role is, in my terms, to review and rule, so to speak. But what does investigation look like? Is it someone appointed to reach out, or is it another entity that's going to collect more information when we're talking about investigate? What?
So I will take a brief stab and then I'm gonna kick it to Meredith to really dive into it. But our experience has been that there is an attorney appointed to us. We have that initial discussion, initially, who do we wish to speak with? What information we would like to see, what documents, things of that nature. But we work through the attorney who coordinates with the city, with Meredith's office, I believe.
So as Krista was
We
saying.
don't have visibility into the.
We don't
process.
investigate. We're not the investigators.
We ask for whatever evidence we want.
Right, so your investigation is, like I'm looking at this and one of them was, you know, if we had seen their filings or if we had seen this email or we had seen this, so you'll ask that attorney who then asks the city clerk to provide this. And then you also have a list of witnesses. You know, I think Mr. Salt would be a great person to talk to, so I'm gonna ask that you put this on the list. I think that so-and-so would be a great person to talk to, put them on the list. And then we subpoena them and ask them to come and testify in front of you, so they can give a statement, but you can ask them any questions that you want. They do have a right to be represented by an attorney. So the investigation is really your first pass going, well, if we're gonna rule on this, this is the information we need, and we call that your investigation.
Well, and to that end, the one about, I don't remember which one it was, but regarding the voting, right? And I would like to know the voting record and who voted in affirmative for, that alleged conflict. And so I might want to speak to those council members that voted for this to see if there was any, because there was no abstention and there was no disclosure, was there also influence in that regard?
What's the penalty if they don't show?
We say very bad things about them and give them a miscopied paper.
Since
There's no penalty.
There's no penalty.
I have no
So-
enforcement
So
powers.
they could not show and where do we go?
You can dismiss it if it was someone that was supportive of the complaint, but no, I don't actually have legal authority to subpoena somebody unless they're an employee.
But part of our revisions, there's some language in there that says if you file a complaint, you have to cooperate. And if we ask
I
you
thought-
questions and things of that nature, much better language than that, but the intent is if I'm going to go through and swear and sign a complaint, I should be required to participate and to provide whatever I can provide.
So the subpoena power will be enforceable against a city employee or another elected official, because if that other elected official doesn't come up, then somebody else can file a complaint against them, or you can self-initiate a complaint against that. I have no ability to force a third party to come in here.
Since there's a lot of new members, Meredith, would you go over that process where once we agree to investigate, you step out and an outside attorney comes in? Because that might be a little strange if all of a sudden you're not there for them.
So once a complaint comes in, I look at it to see if it meets the minimum qualifications. I write you a little memo and it gets attached to an agenda and you'll have a meeting. At that meeting, that is what we consider your first hearing. You will have a designated outside attorney sitting there. Because I am the legal representative for all boards and commissions, I am conflicted out because then I cannot provide you legal advice in contrast to one of my clients who is sitting there, basically the defendant. So from that point, once I look at the complaint, it's hands off for me and you have the outside attorney. He will sit there through every single meeting. They'll provide you guidance through our code, could provide you guidance through state law and help you along with process and procedures. The last two that we have used have both been previous trial attorneys. The second one is also a sitting judge for a couple of different municipal courts. And so these attorneys are very familiar with how to run a trial. And so they will try to help you narrow down the evidence and assist with questions if you need it.
Do we keep us, the same person for a while so that they understand our code of ethics?
You keep the same attorney
That's-
throughout the complaint.
Just the complaint?
You may not get the same one because there is a tight window time frame on how fast you must hear these. And I am dependent on their schedules, whether they're in court or whether they're sitting as a judge. But I will endeavor to try to just use these two because they are familiar with it and they have both seen the revisions to this code.
Yes.
But what happens is once the complaint comes in, I check to see which one of them is available and they then get copied on all correspondence that we have. And they will sit down and I actually talk to them and say, okay, this is who this person is. This is the board they're in. And, not really tell them about the case, but more the dynamics, like this is the planning and zoning board. This is the chair. This is not the chair. And any information that I could provide that way, but I'm hands off because I do have a conflict of interest because I can't represent both you and the other elected official or appointed official.
And is it typically a city or a county judge that you said as a possibility or?
No, I used two attorneys. One of the attorneys, Mr. Kerwin, who had, I think did the last two for you, is a municipal court judge for several other cities, and he's a city attorney for some other cities. But this is the only time we use these attorneys. I don't use them for any other matters, so they're not beholden on the city for any contracts. Their only contract with us would be to hear a complaint. This is their sole business. They have no reason to ever appear in front of that board, like be a council member, to get their vote on the contract. So there is no conflict for them. But these are not elected officials. These are sitting attorneys that are practicing.
And they serve to guide us if we have questions. They're not running the hearings or the investigation. they're there. If we say, you know, if we have a legal question, or want some more definitions or understanding.
And they both have 25+ years experience.
What other questions or comments? Relating to
How
the
many
audit?
complaints have we had that have gone to investigation in the last 5 years?
Right?
True enough.
I think it was ever since this commission has been created, there's been three, I
There's
think.
been 3 that you had to pass, go or no go on.
Mhm,
One of them, I believe, was refiled.
mhm.
Um,
One,
one of them had a city attorney get out of jail free card attached because I had provided them a written legal opinion prior to them taking the action that was complained against. And that y'all didn't go forward with that. One of them you had a full-blown
investigation.
month. And the other one,
Only one has gone to second like the full
Yeah.
public hearing with interviewing and discussing the actual investigation itself.
and these were all within the same year. So within 5 years, we had 1 year that had 3 complaints.
Thank you.
And that speaks to the quality of candidates we have in this city.
Absolutely.
No, but our policy and the structure of the way our government is set up here deters people running or behaving unethically. We like to be like the Maytag repairman and just do nothing.
One last thing before. I just want to congratulate the board because we spent the last year going through all of those changes and, that went through its first reading. So I think that was just wanted to acknowledge. It was an ongoing lengthy effort for this board. So the track changes continue to move through the process. Yes.
Some of you may be on that committee.
Is when they'll be ratified?
Next Tuesday will be a second reading and they'll be effective of the final vote. So yes.
Great, thank you.
Any other comments or questions on the article of interest?
Thank you.
That is
Yeah.
great, lots of
Mhm.
substance.
That was good.
May I have a motion to adjourn?
Motion to adjourn.
Second.
All in favor?
Aye.
All right.
Meeting adjourned.